you all. Now we will discuss on share-based employee benefit and sweat equity regulations. In our earlier videos, we have covered. In one video, we have covered chapter 1. In another video, we have covered chapter 2. Now we are talking about chapter 3 of share-based employee benefit and sweat equity regulations. Now I will take you to SEBI official website. I'll share you the screen. Go to Google, then type SEBI, sebi.gov.in. This is the Securities Exchange Board of India official website. Go to legal and then click regulations. There you will find all regulations, SEBI regulations. Here if you see Securities Exchange Board of India share-based employee benefit and sweat equity regulation 2021. Click this, then you will find the regulations. In our earlier video, we have covered this chapter 1, share-based employee benefit and sweat equity regulations effective from 13 August 2021. Chapter 1 talks about the preliminary, short title, commencement and application. And complete definition part we have discussed in the chapter 1. And in another video, we have discussed on chapter 2. This is chapter 2 talks about the schemes, implementation and process. Chapter 2, implementation of the schemes. This we have discussed through trust route. This is what we have discussed, implementation of the schemes and these percentages, these limits. We have clearly discussed where it is applicable, how it is applicable, and what are the limits and eligibilities also. We have discussed about the eligibility and we discussed on compensation committee. We have discussed on shareholders approval, where shareholders approvals are required. And we have also discussed on variation of terms of these schemes. We have also discussed on winding up of the scheme and non-transferability. We have discussed thoroughly on chapter 2 and listing also we have discussed schemes implemented by unlisted companies, that also we have discussed. Compliances and conditions also we have discussed, and disclosures, certificates from auditors and accounting policies. These are all we have discussed under chapter 2 in our earlier video. Now we are discussing on chapter 3. Welcome to chapter 3. This we are talking on administration of the schemes, specific schemes. Total 5 schemes we are going to discuss. We are discussing on administration. We are discussing about employee stock option scheme, that is ESOS, which is covered under Part A, Chapter 3. Part B talk about employee stock purchase scheme, ESPS. And Part C talks about SAR, stock appreciation rights. Part D talks about General Employee Benefit Scheme, GEBS. And Part E talks about retirement benefit schemes, RBS. So we are going to discuss the administration of total 5 schemes, Part A, Part B, Part C, Part D, Part E. So first we are talking on employee stock option scheme, ESOS, Part A of Chapter 3. Administration and implementation, how it will be administered and implemented. Subject to the provisions of these regulations. These regulations means SEBI share-based employee benefit and sweat equity regulations. And ESOS, employee stock option scheme, shall contain the details of the manner in which the scheme will be implemented and operated. In the scheme only we'll give full details how it is implemented and how it is operated. We have discussed in chapter 2, the schemes will be implemented through trust. Then we have discussed complete about the trust. Then no ESOP, employee stock option scheme, shall be offered unless the disclosures. See, in the scheme itself, we have given what are the disclosures are required. And when we are giving grant letter to the employee, there we have to give complete disclosures. That is what this is talking about, the disclosures and pricing. The company granting options to employees pursuant to employee stock option scheme shall be free to determine the exercise price. See, this is predetermined price. How the price will be decided? This is company has a company can freely determine the exercise price subject to confirming accounting policies and vesting period. The minimum vesting period is 1 year. 1 year, it is a mandatory. And beyond 1 year, yes, it is a discretionary of the company, discretion of the nomination remuneration committee, that is a compensation committee. It may extend to 2 years, 3 years, 4 years, 5 years, and every year in tranches 25%, 20%, like up to these 100% can be divided into the tenure. This is the decision of the company, that is compensation committee, but minimum vesting period is 1 year is a mandatory. Accordingly, the policy has to be structured. The company implementing employee stock option scheme shall frame appropriate policy with respect to the death, permanent incapacity of the employee subject to compliance with applicable laws. In case the employee died during the tenure, there is a death or permanent incapacity, then there is no need of waiting period. This vesting period shall not be applicable. Even 1 year of mandatory vesting period shall not be applicable in such instance. The options shall vest in terms of the sub-regulation 4 of regulation on the date of death or on the date of permanent incapacity. Then we will talk about the rights of the option holder. And there is another lock-in period. It is not mandatory. Company may specify lock-in period. What is this lock-in period? Even after exercise, company may say the shares will be lock-in for a period of 6 months or 1 year. But this is not mandatory. Rights of option holder. An employee shall not have a right to receive any dividend because this is the only option. It is not, once exercise only he will get the rights. Till that time, employee shall not have any right to receive dividend, any right to vote, in any manner enjoy the benefits of available to the shareholders in respect of an option granted to him or her. How long? Till the shares are issued to him or her upon exercise of the option. What is the consequences? What are the consequences of failure to exercise an option? Suppose if the employee forgot or failure to exercise his option during the given time, what will happen? The amount paid by the employee, if any, at the time of grant, is it mandatory to pay the amount at the time of grant? No. Some companies will fix some amount, minimum amount, but it is not mandatory. If any amount is paid at the time of a grant or vesting or exercise of the option, and the employee failed to exercise an option, then he may be forfeited by the company if the option is not exercised by the employee within the exercise period. Whatever the amount paid at the time of the grant or vesting or exercise, that may be forfeited by the company if the option is not exercised by the employee within the exercise period. May be refunded to employee if the options are not vested due to non-fulfillment of any conditions. See the difference. If any, it is not vested due to non-fulfillment of any condition, then it will be refunded. It is vested but not exercised during the time, then amount will not be refunded. In case any non-fulfillment, if the options are not vested, then amount will be refunded. That is the difference. This is what about Part A, that is employee stock option scheme. Now we will come to administration of Part B. Very simple. Part B. Part B talks about employee stock purchase scheme. See the difference. Employee stock option scheme we have discussed. Now we are discussing employee stock purchase scheme. This is ESPS. Earlier one is ESOS. ESPS generally it will be at the time of IPOs, public issues. At the time of public issues, we'll discuss about employee stock purchase schemes. Well, we'll discuss on administration and implementation of ESPS. Subject to the provisions of these regulations. These regulations means SEBI share-based employee benefit and sweat equity regulations. An employee stock purchase scheme shall contain all the details in a manner in which the scheme will be implemented and operated. So we have to give all the details of implementation and operation in the scheme itself. And we will talk about pricing and lock-in. Company may determine the price of the shares to be issued under ESOP, employee stock purchase scheme, subject to confirming the accounting policies. Accounting policies are discussed in Regulation 15 of these regulations. Shares issued under employee stock purchase scheme shall be locked in. In this case, it is mandatory. Earlier case, employee stock options case, I told lock-in is not mandatory. But here it is lock-in is mandatory. Minimum period of 1 year from the date of allotment. Because I told these ESOPs, employee stock purchase schemes will be allotted in public issues. So there will be a lock-in period. Lock-in period of minimum 1 year from the date of allotment. Provided that in case where the shares are allotted by the company under employee stock purchase scheme, in lieu of shares acquired by the employee under employee stock purchase scheme in any other company has merged or amalgamated. So it is like if company merged or amalgamated with other company, then the lock-in period will be adjusted accordingly. Transfer company employee got employee stock purchase scheme options under employee stock purchase scheme. Then suppose the lock-in period is 1 year or 2 years. Then because the minimum is 1 year, then in earlier company has already worked for 6 months. The company got merged with other company. Then the balance period only he has to calculate 1.5 year. This is what is discussed in this provision. In the event of death or permanent incapacity of the employee, the requirement of lock-in shall not be applicable from the date of death or permanent incapacity. This will be vested. In employee, if employee stock purchase scheme is a part of a public issue, IPO, I told you, IPO, public issue, the shares issued to employee at the same price as in the public issue. Then the shares issued to employee pursuant to employee stock purchase scheme shall not be subject to any lock-in. The reason is, if the employee is getting the shares through public issue at the same price like public is getting, then there is no sense of lock-in. That is what is explained in this provision. Then we will move on to part C. That is the third scheme. Stock appreciation right scheme. This is also called SAR scheme. Then we will talk about administration and implementation. These complete details subject to these provisions, subject to the share-based employee benefit and sweat equity regulations, the SAR scheme shall contain the details in a manner in which the scheme will be implemented and operated. So all the details shall be mentioned in the scheme itself. A company shall be free to implement a cash settle or equity settle. Here you will find two ways. SARs will be settled. Either maybe cash settle. If settling through cash, it is called cash settle. Settling through equity shares, then it is called equity settle scheme. Equity settled SAR scheme. In case of equity settled SAR scheme, if the settlement results in fractional shares, then how fraction share will be given? Then the consideration for fractional shares will be settled in a cash so that it will be settled. Then no SAR shall be offered under any SAR scheme unless disclosures are specified in Schedule 1. See, this is part of the Schedule 1. When offer letter is giving, then there itself, all the details will be, all the disclosures will be given as per the part G of the schedule 1. What about vesting? These there shall be a minimum, there shall be a minimum vesting period of 1 year in case of SAR scheme. We have a minimum vesting period visa, even employee stock option scheme. Here also, minimum, there will be a minimum vesting period of 1 year in case of SAR scheme, provided that in case of SAR where SAR is granted by a company under SAR scheme, same we have discussed, no, like merger amalgamation. The employee received SARs under SAR scheme and that company merged with other company and the vesting period is 2 years, for example, then already the vesting period in the present company, that is transfer company, that period will be adjusted accordingly in case of merger and amalgamation. In case of death and permanent incapacity, on the same day, the option shall vest on the death of the permanent and incapacity, and no need to wait for 1 year or no need to wait for balance period of vesting period. And all the details, the company implementing SAR scheme shall frame an appropriate policy. The details shall be mentioned in respect of death or permanent incapacity of an employee subject to compliance with applicable laws. All the details shall be mentioned in the scheme itself. What about the rights of the SAR holder? The employee holding a SAR shall not have the right to receive dividend or vote or any manner enjoy the benefits available to the shareholder, because in respect of SAR granted to him or her until exercise, he will not have any right of dividend or vote. General employee benefit scheme. Next we are going to part D. This is the fourth one. General employee benefit scheme, GEBS. Administration and implementation. Full details shall be mentioned in the scheme itself. Suppose the shares of the company or shares of any listed holding company. There is a one class in this specific class in general employee benefit scheme and retirement benefit scheme, because see the shares of the company, the class talk about the shares of the company or the shares of its listed holding company shall not exceed 10% of 10% on what? Either book value or market value or fair value, whichever is the lower of the as per the latest balance sheet of the total assets of the scheme. First, we have to calculate the total assets of the scheme as per the book value, market value, and fair value, and we have to take whichever is lower on the 10%. So the shares of the company or shares of the listed holding company shall not exceed 10% of book value or market value or fair value, either of the one, of the total assets of the scheme, whichever is lower. Calculate 3 and whichever is lower, as appearing in the latest balance sheet, whether audited or limited reviewed, for the purpose of general employee benefit scheme. The secretarial auditor of the company, there is a company secretary, practicing company secretary, who is a secretarial auditor, shall certify that this provision has complied with. Then the last scheme, that is a retirement benefit scheme. Under Chapter 3, Part E, we are talking about retirement benefit scheme. Administration and implementation details shall be given in the scheme itself. Retirement benefit scheme may be implemented by a company subject to compliance with these regulations and provisions. That means SEBI share-based employee benefit and security regulations in relation to retirement benefits to the employees. The retirement benefit scheme shall contain the details of the benefits under this scheme and the manner in which the scheme shall be implemented and operated. The same class which we discussed, 10%. So the total assets of the scheme, you have to calculate book value, fair value, book value, market value, fair value, and take the lowest value on the 10%. So the shares of the company or shares of the listed holding company, either of the one, shall not exceed 10% of book value of or market value or fair value of the total assets of the scheme, whichever is lower, as appearing in its latest balance sheet. Either it is audited balance sheet or limited review balance sheet, for the purpose of retirement benefit scheme. The same provision is there in general employee benefit scheme. In general employee benefit scheme, the benefits like death benefit, accidental benefit, medical benefit. In retirement benefits will be discussed. So secretarial auditor again has to give a certificate as the provision is complied with. This is what the administration and implementation of the schemes under Chapter 3 of Share-Based Employee Benefit and Sweat Equity Regulation. We have discussed all Part A, Part B, Part C, Part D, and Part E. Total 5 schemes: employee stock option scheme, employee stock purchase scheme, and the stock appreciation rights scheme, and general employee benefit scheme, and retirement benefit scheme. We have discussed about the administration of the all 5 schemes. Thank you. And next, we are going to discuss on chapter 4 on sweat equity share in another video. Thank you.